So, as the court knows, I'm not a citizen, resident, or person. And I had the free right to travel to Texas.
That's now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. This is a time set for a hearing with respect to Mr. Hillygus' custody status in case number CR 19-1535. Would the council please state their appearance?
Amos Stege, prosecutor for the state.
Thank you, Mr. Stege.
Kate Reynolds with the Washoe County Public Defender's Office, who's been appointed with respect to the competency matter and the custody hearing.
Very good, thank you. Good morning. Good morning, Mr. Hillygus.
Mr. Hillygus, and I would object to this hearing as lacking subject matter jurisdiction, personal jurisdiction over me. I object to the due process. I've not been provided notice or service of any documents of any kind. So therefore, I'm unprepared to be able to argue my case, but I object to this hearing.
Thank you very much. All right. This is the time we had set for the court to consider changing Mr. Hillygus' custody status. I indicated that I would consider changing his status to allow for something like house arrest, GPS monitoring, and check-ins so that he could be released, possibly released, subject to supervision and restrictions from the Washoe County Jail pending resolution of his competency hearing and other proceedings. The standby counsel at the court's request filed a short motion late last week, and then the state filed just recently, I believe this morning, an opposition to the motion. So the first question is, Ms. Reynolds, have you had a chance to review the state's opposition and possibly discuss it with Mr. Hillygus? If so, tell me. If not, if you need more time, we could postpone this for an hour or so, give you a chance to look it over. I don't want to rush you if you haven't seen it or just saw it.
Your Honor, I've reviewed the state's opposition. I have not had a chance to show it to Mr. Hillygus. I don't know if I would need an hour, but if I could have 10 minutes.
10 or even more, I can come back on the bench approximately 5 minutes to 12, and we'll see how things stand at that time. And because I don't want anyone to feel like they're not as prepared as they need to be. Mr. Stege, any comments there? You were directed to follow something, at least a business day or a court day before this hearing, but then you didn't. What happened?
The court may know I have having staffing issues with one deputy being out of the office on FMLA, and I have two deputy DAs on my team in jury trial this week, including one in this department. So it's simply a matter of things slipping away from me and having to, unfortunately, deprioritize.
All right. Well, if there's prejudice to Mr. Hillygus, of course, we're going to make sure that it's mitigated. But if it's a matter of just looking over the very brief response of the state, and then we're ready to go, we'll visit that in about 10 or 15 minutes. So we'll be in recess until close to 12 o'clock. All right?
All rise. All rise. This court is again in session.
Thank you. Please be seated. All right, Ms. Reynolds, do you need additional time, or are we ready to go?
Your Honor, I've reviewed the pleadings of Mr. Hillygus with respect to this hearing, and we're ready to go.
Thank you. All right. So the court reviewed the motion and what was filed, I think, by Mr. Prasad. It was a bit scanty in any details that the court could grab onto to suggest that Mr. Hillygus would follow the rules, have a safe place to live, adhere to house arrest, otherwise be supervised sufficiently to protect the community and also ensure his appearance at all court appearances. The state then responded, of course, with concern that it had listened in on, recorded phone calls from the Washoe County Jail, it's allowed to do, that suggested that Mr. Hillygus had no intention of cooperating in the third evaluation, had no intention of wearing any kind of monitoring if he was released, or even staying in Washoe County. It's a motion of the of Mr. Hillygus, so I'll let you go first, Ms. Reynolds. Tell me anything you'd like the court to consider. If you want me to hear from your client with respect to where he's planning to live, who he'd live with, whether he would commit to staying in Washoe County if that was required, whether he would commit to staying on house arrest other than for things like medical care, buy food, church, meet with his attorneys, standby counsel, things like that. I'll hear from him. But I need something in order to base a court's decision to change his custody status under the statute. After I hear from you and possibly Mr. Hillygus, I'll hear from Mr. Stege. Ms. Reynolds.
Your Honor, I have just spoken with Mr. Hillygus. I do not believe he believes it is within the power of this court to order house arrest or to require him to stay in Washoe County. He would continue to dispute the subject matter jurisdiction of this court over these proceedings. With respect to the defense or the standby counsel request for an OR release, I would simply note that Mr. Hillygus does not have a violent history. He's not a safety risk. This case involved allegations concerning his mother. She is now deceased. He would not be a care provider in that sense. So I think all of those factors weigh in favor of a release for Mr. Hillygus.
Where would he live though? Where would he go? Because I have never released anybody on pretrial supervision without both knowing and having a level of approval after hearing from the state. And we know where the person's going to live and can confirm they're going to stay there unless and until the court allows them to move somewhere else. Do we know the answer to that or do we not at this point?
Your Honor, I would caution Mr. Hillygus to not discuss the facts of this case, but if he would like to address the court to provide any detail on that.
Okay, Mr. Hillygus, so here's the deal. I understand you have issues with the court's jurisdiction. I understand you object to the proceedings. I understand you don't like how any of this is going down. You're in the competency evaluation stage of this process. If I'm going to change your custody status, I need more than your view of how things are or should be. I need more than you don't have a violent history. I need more than that the issue that brought you before the court had to do with your late mom and actions that you've taken in respect to that. Where would you live? Who would you live with? Will you agree to stay supervised by the court? Will you agree to house arrest if I impose that? Will you agree to wear tracking? Go ahead, sir.
So, as the court knows, I'm not a citizen, resident, or person. I do not reside in this county. I do not reside in another county in this state. I'm domiciled in Texas, and I had the free right to travel to Texas. There was nothing restricting me to travel anywhere in the United States. I had traveled many times over the last 3 or 4 years that this has been going on to many states, and I moved to Texas. I filed documents with the court. The court must remember that I challenged your jurisdiction on February 2nd. I also challenged your jurisdiction back in October of 2021. At that time, in October, when I challenged your jurisdiction, we had a Feretta hearing. At that hearing, it was determined by you that I was competent to handle my own case. There was a Feretta hearing held, and I was determined not to have standby counsel. That was part of the order that came from the court. I then challenged you through what's called a motion to recuse you. That was ruled on.
Motion to disqualify. Right.
A motion to recuse, a motion to disqualify was filed with an affidavit from me and 4 other witnesses that were in court that day, challenging what was said in the court that day, because cameras were not allowed on that day, and the record, the transcript by the court reporter was changed at your request, because we have a recording of what was said in that hearing, and it's not what the transcript says.
Let me hit the pause button. Here's what I need to know for purposes of today. I need you have to stay in Washoe County. I'm not going to let you leave this county when these cases proceed. If you say, Judge, if you let me out, I'm going to go to Texas, that's a non-starter. Judge, I can go anywhere I want because you don't have the right to tell me I can't, that's a non-starter. If you say, Judge, I need you to say and mean it, that if I release you from the jail, because I told you this before, I take no pleasure in the fact that you're up in the jail pending this case, pending the determination of competency, pending the trial date coming up this summer. I'm not looking for reasons to keep you in the jail. I am looking for reasons to keep you coming to court. I am looking for reasons to make sure we know where you are. I'm looking for reasons to make sure that if you abscond, we can get you back here. But I'm not looking for reasons to keep you lingering in the Washoe County Jail. If you're gonna stay in the jail after this hearing, it's because you're putting yourself there. I wanna find ways to get you out, protect this community, and make sure you come to court. So tell me this, where would you leave? If you were released from the jail today, where would you go? Where would you spend tonight?
I don't have any family in this community. I don't have anywhere to go in this community.
Well, some people find themselves in that situation. People sometimes are on Highway 80 and they get arrested for doing something bad. Say they're carrying drugs or something and they get pulled over and they're arrested and they're in the jail. And they come to court and they want to be released pending their trial. Sometimes the judge lets them go back to the state they came from. Sometimes the judge says, you're going to have to find a place here in Washoe County while the case proceeds against you. I'm not from Washoe County, but you committed a crime here or you're alleged to have committed a crime here. And you have a history of not showing up for court. We need to make sure you're going to be here. So I need a place in Washoe County. If I'm going to release you, I'm not letting you go back to Texas, Kansas, California, Arkansas. I'm not. You've got to stay here. I need to know where you're going to be. Also, you'd have to agree to house arrest, which means you have to stay at home unless you're going out for some, solid reason. The list of reasons we let people on house arrest. And then with a GPS monitor, you fled. It took us 6, 8, 10 months to get you back here, and then you fought extradition. Trial's coming up. That's a risk the court's not willing to take. But if you say, Judge, here's my place, I'm living with my friend, she comes to court, takes the oath, says, yes, I live at this place, I have a lease or I own the home, Mr. Hillygus can live with us. You agree to check in regularly, you agree to wear a monitor, I'll probably let you out, but I don't have that right now. I have you being mad at the system, I have you being mad, challenging the court's jurisdiction, I have you being upset with the way things are going, which I'm not telling you to think a certain way, sir. I'm just saying, for purposes of me changing your custody status, I need to have something more solid than your views of things.
Well, I would object to claiming that I fled. I did not flee. I filed documents on February 9th, the day that you ordered me for a psychological evaluation, that I did not consent to that psychological evaluation. I challenged your jurisdiction at that time. I filed another document.
That doesn't change the court's legal right to bring you back here, though.
I did not flee the state. I filed documents challenging your jurisdiction and you have not ruled on those. I filed 3 writs of error, which are on the record that you have not ruled on. I filed a writ of habeas, which you have not ruled on, that also challenged your jurisdiction, because there is no probable cause, there is no victim, there is no injured party in this case. You do not have jurisdiction over me. I'm a natural, living, flesh and blood man. I'm not a fiction. I'm not a corpse. I'm not a vessel. I'm not a transmitting utility. I am a living man. I am here challenging your jurisdiction. I am domiciled in Texas. I do not have any family in Washoe County. I'm not a resident of Washoe County. I do not have any friends that are going to put me up in their house. I'm not going to pay money to go out and be not free to fight this case, because the case should be dismissed. If you were to review those documents, you would find that this case should be dismissed and that there's no reason to keep me in the county jail. I'm not going to go out and say I'm going to live somewhere in Washoe County and pay money to have you track me, which is a violation of my constitutional rights. I have constitutional rights as one of the people. You've sworn an oath to uphold the Constitution. I'm asking you that you follow your oath and you dismiss this case with prejudice, because when I was in Missouri, that was on a false bench warrant. I have not even seen this governor's warrant. I've not seen any documentation. I do not have all the discovery, and it's my right to fight extradition through a writ of habeas corpus, which I was denied.
Okay.
I asked to be,
I need you to wrap this up, because now we're going to to your view of whether the court has jurisdiction to proceed, whether you committed a crime, whether the state has, whether there was probable cause to bring this case again. That's your view of things. Okay, I get that. But right now, I'm trying to find a path forward to let you out of jail. And you're not helping me. You're not helping me.
Can we stipulate to some facts here?
Well,
That I have not seen a governor's warrant or an affidavit of probable cause or a complaint by a victim in this case. Can we
Okay.
stipulate to that?
well, stipulate means there's agreement. And
That's right, there's an agreement.
We're not at that, this is not a hearing for that, nor is the state stipulating to that as I understand it. So let's do this.
Stipulate that I'm a living flesh and blood man.
Okay, so
Can we
hold on.
stipulate to that?
Mr.
I'm here in
Hillygus.
court.
Mr. Hillygus, in a moment, I'm going to have to wrap things up with you, then I'm going to hear from Mr. Stege. You've heard the court's concerns. This is the period of time between now and when I see you on June 12th, I believe, Monday morning, where we have a hearing on competency. But I understand your position. You may have a seat. Ms. Reynolds, you may have a seat at this point. I'll give you a chance to address the court in a moment. Mr. Stege, what's your view of things?
I also was struck with the, sort of the paucity of the pleading by the,
Well, it was lacking in detail, wasn't it?
lacking in detail, and, I know Mr. Prasad and Ms. Reynolds as well to be very zealous and skilled advocates. And so my reading wasn't that it was lacking in details because of any oversight. My read was it was lacking in details because of their duty not to file frivolous motions, right? I mean, what does this contain? That he won't stay here, and they hope or believe that someone may show up today to sort of to vouch for the defendant. Taking a step back, bail it's an evidentiary-based hearing. There's no evidence, right? And as much as, frankly, it sort of hurts the state's ears to hear the court really wants to let the defendant out, I think wrongly. The practice here and case law supports and the statute support, if you flee the state, you deliberately flee the state and have to be brought back here, the idea that you're OR'd on your word to appear, that's a difficult proposition. If you flee in the way that the defendant did, it's rare that someone in his position would be let out. Add on top of it, even rarer, a defendant who has been declared a vexatious litigant. We all know, sort of in the vernacular, having dealt with vexatious litigants, but here is Mr. Hillygus. I mean, there's findings of fact and conclusions of law out of this district that he is vexatious, that he does not and will not follow court orders. And here today the court's saying, say this, say it. Repeat the words after me, so I'll let you out. You can't even do that. Now, the court should not let him out for all the reasons I outlined before. And I would like to present some evidence today because
Go ahead.
I call Sean McVickers. And while he makes his way to the stand, Your Honor,
Hold on one second. Go ahead.
the defendant failed to comply with a meeting set with a third evaluator, and he refused to meet with that person on May 18th. That's part of what I'm about to present. But that should add to all of this. So whatever he says today, based on his actions, shows he will not follow any court order. So.
All right, well, that's our argument, and factually, if you didn't meet with the evaluator, that's a fact. But let's hear from this witness. Would you please raise your right hand and take the oath of witness?
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Please have a seat. And the witness stand. Okay, slide in. You can adjust the microphone to put it in front of your face, and when you're ready, would you please tell us your name and spell your last name?
Investigator Sean McVickers, last name McVickers.
All right, Investigator McVickers, thank you. You may proceed.
You are employed with who?
The Washoe County District Attorney's Office.
And you have done some investigative work in this case, correct?
I have.
And you've attended a number of hearings involving defendant Hillygus.
Yes,
And as a consequence, you're familiar with both his appearance and his voice.
I am.
You've heard him speak both today and on other occasions.
That's correct.
And in your capacity as an investigator, do you have access to the jail phone call system?
I do.
And did you have occasion to listen to a series of phone calls of defendant Hillygus occurring on or about May 18th of this year?
I did.
Those being phone calls to Matt Scarlatos.
That's correct.
And have you heard, you're familiar with Mr. Scarlatos' voice?
I am.
Have you heard his voice before?
Yes.
You've heard him identify himself as Scarlatos.
Yes.
What about, there's a person by the name of last name Hine.
Correct.
Have you ever listened to phone calls between Hillygus and Ms. Hine?
Yes, I listened to one on May 18th.
And what about Barbara Stone?
Yes, I have.
You're familiar with her voice?
I am.
And you've listened to prior phone calls involving her and Mr. Hillygus?
I have.
Now, Barbara Stone, do you know of her involvement in this series of emails pertaining to the court and parties in this case?
It's my understanding that Mrs. Stone is an attorney out of Florida that's an advocate on Mr. Hillygus' behalf.
Well, it's true, she's a disbarred attorney in Florida, correct?
Objection, hearsay.
Do you know that, sir?
It is my understanding that she's been disbarred, yes.
The objection is overruled.
Objection and personal knowledge.
Well, it's the witness's understanding. If you want to flesh out how we came to that understanding, you can.
No, I mean, as we know, the rules of evidence do not apply to bail hearings and or sentencing. This is a bail hearing, so I'm sort of taking for the value that it's worth.
Fair enough.
Do you know whether or not she's the author or contributor to these sort of these Nazi comparison flyers that went out a couple months ago? Ms. Stone.
It is my understanding that she is the author. She's made references to those documents in telephone calls with Mr. Hillygus.
And had sort of coordinated or talked about what the content or who the targets of those ought to be.
She has.
Sort of similar type or temperature of language is used by Ms. Stone with Mr. Hillygus in discussing the, I guess, participants in this case,
She has.
including terms like accusing, judges, politicians, law enforcement of being human traffickers,
That's correct. She uses that term often.
as well as Nazis.
Correct.
And that's terminology, have you ever heard Hillygus agree with sort of those assessments of the people referenced?
Yes.
I want to ask you, so those May 18th phone calls, you have occasion, it may have an exhibit sticker. Madam Clerk.
You can approach the court clerk.
Exhibit 1, marked for identification.
Sir, please review proposed exhibit 1.
Okay.
You recognize that thumb drive?
I do.
Did you have occasion to review the contents of that thumb drive before testifying this afternoon?
I did.
And did you recognize the contents of it?
I did.
What is contained on that thumb drive?
3 telephone calls that were placed from Mr. Hillygus at the Washoe County Jail to 3 individuals on May 18th, 2023.
Other than being a copy, is that a fair and accurate depiction of those originals which you have access to at the jail?
They are.
I move in 1.
Objection.
Your Honor, Mr. Hillygus would object with respect to authentication, noting that it does not appear Mr. McVickers has ever met Barbara Stone or Matt Scarlatos.
Objection's overruled. You may publish.
I want to ask ask you, as I queue up here, if you can, across these 3 calls of May 18th, was the subject of meeting with a competency evaluator discussed by Mr. Hillygus?
Yes, these 3 calls were placed on May 18th, 2023, after Mr. Hillygus described meeting with a psychologist from NAFCARE that same morning.
And did he say whether, across these 3 calls, whether he had in fact participated in competency evaluation with this psychologist?
He described meeting with a psychologist briefly and not consenting to the evaluation and refusing to participate.
Let's play some portions of the call with Scarlatos, please.
Or monitored except for privileged communications between attorney and client.
My cell at 7:30 and said, be ready to go down to the infirmary in about 20 minutes. And then at about 10 to 8, some deputy was here to escort me and roll me down to the infirmary. When I got there, a woman named Nicole that works for NAFCARE, she's a med tech, came up and said, I'm going to be taking you back to do something, or I can't remember what exact words that she used. And I said, well, can you tell me who the doctor is and what's it regarding? And she said, oh yeah, I'll let you know. And then she came to roll me back there, and as she was rolling back there, she said, oh, it's a psychologist named Nicole Mack out of Colorado, and she's going to do a teleconference with you over the computer. And she set me in front of this computer, and she said, I'm going to stay in the room while I can do this. And I was real polite with Nicole Mack, the psychologist from Colorado, and I asked for her consent form and for a contract explaining who she was retained by, who she's employed by, who she's being paid by. And she said, well, we have a consent form. And so they sent it over. She emailed it over right away, and they printed it out and brought it to me. I got a copy, and I can read you what it says, but at the top, I said it's review for consent, and at the bottom, I said, decline to contract with your corporation. I do not consent to violate my right as a criminal defendant has a right to remain silent. And I signed it under duress, UCC 1-308. Well, and it was over, so.
Let's continue to 8 minutes 50.
Well, to Krishna, I said, why would I go be locked up in a room at a house, or what's different? There's nothing much different.
And this, for context, here, Hillygus is talking about being on GPS.
That's correct.
House arrest with a tracking monitor. I mean, there's no difference in being in here.
And you've got microphones and cameras hidden everywhere probably in this place. You wouldn't get hurt. I mean, seriously, these are the kinds of things you would have to ask.
Well, yeah, no, they want to know where I would go, and that I would be on house arrest. So if I got to tell them, oh, I'm going to go live with so-and-so here in Reno, Washoe County, but I don't want to impose on anybody. I don't have any place to go. So.
Well, you have a property in Nevada, don't you, still? I mean, if you wanted to go there, could you go there?
I don't believe so. It's there's no place for me to go there. It's rented out. So.
I mean, I'll be honest with you, but that really
Now let's go to
minimizes the.
Let's go to portions of the Hein call.
Please remain on the line. Hold for acceptance.
Honor,
possibly
Mr.
can.
Hillis-
Excuse me one second, please hit the
Yes.
pause.
Mr. Hillis would ask that the entire phone call be played, just as, to put everything into context.
The entire call with Mr. Scarlatos.
Yes.
How long is the call?
Each call on this disc runner is 15 minutes long.
Okay, court doesn't have time for that. I'm in the middle of a trial. I have the jury coming back shortly, but you can make an offer of proof if you'd like as to what the other portions of it would say and what the context of it is for purposes of this hearing. Let's proceed to Ms. Hine, please.
Picking up at approximately 5 minutes, 22 seconds.
But, we give them 7 days, you're not even gonna have, you're not gonna even be back in there.
Because I didn't meet, like, I met with Krishna Prasad, the public pretender, and he wanted me to give him an address where I was going to be in Washington County. I said, I'm down
Hit the
south.
pause button, please. Go ahead.
This is this is discussion of attorney-client communication.
Well, he's communicating this not with his attorney. It's not a recorded phone call, so it's hard to understand the expectation of privacy. I'm sure there are other reasons why the court could let this in. What do you think, Mr. Stege?
Yeah, I agree. Privileged communications, when shared with people who aren't within that sphere, lose sort of their protection. And this portion will not cover hardly any more than anything that's discussed with Mr. Prasad is offered for the purpose of the defendant stated that he is domiciled in Texas and has no connection here.
All right, so based on that, the objection is overruled. You can continue to play the call.
I don't live here, I'm not a resident, I'm not a person, I'm not a citizen.
Maybe we should name them specifically so that they know they don't have any authority to do anything on your behalf, because they're still out there as loose cannons.
Now, who are you talking about now?
Krishna
Oh,
and
no,
the other one.
yeah, Krishna.
Yeah, you really shouldn't even be talking to them, because they're going to say, oh, well, you know, we got records that was bad, and he told me this, and
So, speaking of that, Barbara wanted me to bring up about what they're, Breslow, the man, wants to put me on house arrest and wants to put me on a GPS tracker. And I'm like, I don't.
no, I wouldn't do it. Once you start to come into their nonsense,
I'm not. I'd rather just stay here until they let me out. I'm not.
This statement shortly before 7 minutes into the call, what did Hillygus say about given the option between being released with GPS and staying in custody?
Mr. Hillygus referenced that he did not want to be imprisoned outside of the jail. He looked at it the same way as being in custody in the jail.
And he'd rather stay in custody than get GPS.
Correct. He also referenced not wanting to pay the fees.
Does this call also contain the defendant's statement about his refusal to meet with the evaluator? The Hine call.
I'm sorry, can you repeat that?
The Hine, does he also mention during the Hine call a state that he has refused to meet with the NAFCAR evaluator that same day, the 18th?
He did, yes.
That's in the interest of time. Let's move to the Stone call.
Ms. Reynolds, I'm going to assume same request that the entirety of the Hine call be.
please remain on the line. Hold for a second.
Before.
I'm sorry, Your Honor.
That's right. I just said that same court ruling.
Let's pick up at.
I'll make a comment after this hearing, when you're done, about these calls, though, on a related issue, not necessarily on the status of his custody. Go ahead, Mr. Stege.
You think all the criminals to be announced.
Right. So the hearing on Tuesday is going to be very short. It's, Krishna Prasad was ordered by the judge to submit a motion about where I would live in Washoe County, which I don't have any place to live here, and they want to put me on house arrest, so I will be confined. I'll be confined, and they want to put a tracking device on me. And I mean,
Well, what is Kathryn's opinion about that?
I'm not sure if we've gone over that completely. I can do that when I talk to her later today.
Yeah, definitely do that when you speak to her later, because,
But Krishna
because I don't get
Prasad,
trusted with her either.
Krishna Prasad was terminated his services through Nevada Rules of Professional Conduct 1.16, thanks to a friend of mine named Barbara. But I put a nice email together explaining to him that he's violating my rights. He needs to get some information out of Missouri and do some other things, get that governor for him, but he's not to file any kind of motion on my behalf. So we'll see if he files something. The judge ordered him to, and I told him not to. So he'll probably
So
file.
what was he supposed to file? Something about where you're going to stay in Washoe County?
Yes, and I told him I'm domiciled in Texas. I'm not a person, resident, or citizen of Nevada or in Washoe County. And so I'm domiciled in Texas, where I receive my mail. That's where I have an account. That's where I get. That's where I have personal property. That's where I lay my head. That's where I'm domiciled. So.
Well, just ask Kathryn her opinion.
For today's purposes, I won't publish any more. That section ended at 7 minutes 50 seconds. And I might just add if I could just add a bit to my argument.
Go ahead.
You know, considering the bail factors, this, and I don't know if there's cross. Sorry, Mr. Reynolds, I sort of jumped in.
Well, hold on one second. You switched gears on me here.
I did. I realized that this investigator McVickers is still on the stand and maybe subject to cross.
Okay, hold on. When I said you can, I didn't understand you to say, can I summarize where we are? No, of course, Ms. Reynolds can examine Mr. McVickers. Go ahead, ma'am.
Mr. McVickers, have you ever met Max Carlatos?
I have not.
Have you ever met Barbara Stone?
No.
And have you ever met Ms. Hine?
No.
No. Your Honor.
Thank you.
Thank you, no further questions.
All right, you may step down. Thank you very much.
Thank you.
All right, what else would you like the court to know? Then I'll hear again from the bench.
Well, I think it's helpful to return to bail factors here. The chief among them, as highlighted during this evidentiary portion, is the connection to Washoe County. There's virtually none left. The defendant is very strong in his desire to disassociate himself from Washoe County. The risk of non-appearance, I think, is very high given the defendant's history. And I think his continued and willful refusal to comply with competency proceedings, while important for that matter, it's also some inference to be drawn here that is consistent with the rest of his presentation to the court, and really goes to his desire or willingness to follow court orders, which any bail order would be. So, in the state's view, bail should not change whatsoever.
All right, thank you. Ms. Reynolds, what else would you like the court to know, please?
Your Honor, Mr. Hillygus has just provided me with the consent forms that he was given at the jail with respect to the psychological evaluations. I've shown them to Mr. Stege. With your permission, if I could approach.
You may.
And really, as pertinent to this argument, what I would note is that,
Well, let me say this. When we're done with this hearing, I'm going to ask the court reporter to make a copy, and that'll be part of this record, and I will give you back the original. Okay. So what's the takeaway here? You're saying that my client had good reasons to be concerned with the process of the evaluation, or?
the takeaway here is that both of those consent forms very much show that you are waiving your right to confidentiality when you do participate in those evaluations. And I would note that Mr. Hillygus, to the extent he declined to cooperate, he even wrote on the evaluation form that he's exercising his right to remain silent. I think there's a difference between being obtuse or non-compliant because it doesn't care what the court thinks and because he is exercising his affirmative belief and really a constitutional right. So I would ask the court to consider that when you consider whether or not to release Mr. Hillygus today, along with really my further argument that he has been nonviolent. While he does not agree with this court's jurisdiction, he has been an active participant in the court process.
To an extent, I would say.
He has been in communication with the court, as he said. While he did leave, he did continue to file motions and continue to keep contact with this court. I would ask that the court consider all that today and make a custody determination.
All right, thank you. Give me just a minute, I want to read this. So the court has seen the notification forms, not necessarily from NAFCARE, but from other providers in the past. I see the signature and the date. I also see the additional information that Mr. Hillygus has written. Investigator, again, please return the original promptly to the defense and put a copy in the file.
Should we mark the copy as Exhibit 2?
Sure, yes.
And admitted or just?
Yes, both pages will be Exhibit 2. All right, here's the court's ruling and a couple additional comments. The court declines to change Mr. Hillygus' custody status. Multiple different reasons, summarized well by this state, but the largest ones are the court is unaware of a place in Washoe County that Mr. Hillygus could go to. Court has concerns that he would be able to be engaged with pretrial release, follow the court orders, wear some type of GPS monitoring unit, and not leave the county. His current contacts here are modest. He's indicated he's domiciled in Texas. That's where he lays his head, among other connections there. The court notes, of course, that he was not located in Nevada at the time he was brought back here for further proceedings. The jail calls as well reflect those types of concerns that the court has just expressed. That's number one. Number two, we have a competency hearing Monday, June 12th, I believe. Does that sound right, Mr. Gaynor?
Wait, so Your Honor, I can double check.
At 9 o'clock.
Yes.
And the court has blocked out the entire morning. If the position of Mr. Hillygus is that he is competent to proceed to adjudication, the concerns that the court's previously expressed need to be addressed. How can they be addressed? Well, the court heard on these calls a thoughtful, articulate man discussing his view of things with other people. So if you want the court during that hearing to listen to the entirety of these calls, then I certainly direct that they be available for the court to listen to the entirety of them. Also, strongly encouraging both sides to subpoena anyone they believe can testify and provide insight for the court's guidance on whether Mr. Hillygus is competent to proceed to adjudication, including those that have sought to evaluate him and been unable to. Third, be prepared to respond to any possible court decision. And what I mean by that is, if the court finds at the conclusion of that hearing, because it is the court's intention to rule from the bench, likely with a recess between the hearing and then coming out and pronouncing a decision. But it's the court's intention to have this matter determined, no later than early afternoon on the 12th. But be prepared for any decision by the courts. For example, if the court finds Mr. Hillygus not competent to proceed to adjudication, the court states its reasons, I want each side to advise the court what they believe the next steps are. Now, the statute's pretty clear on what usually happens. The question is if there's any reason why there's a lawful means to, and whether the court should exercise its discretion to vary in any way. But if the court determines not competent to proceed to adjudication, follow the law, issues an order that Mr. Hillygus be remanded to Lakes Crossing in an attempt to be treated to competency. I want to know each side's opinion on whether the law is as direct as that, or if there's any nuances the court should consider. Alternatively, if the court determines Mr. Hillygus is competent to proceed to adjudication, then I want counsel to be prepared to discuss whether the court ought to fully release the Washington County Public Defender's Office from any further role as standby counsel. The court also wants parties to be prepared to argue whether the court should revisit allowing Mr. Hillygus to represent himself based on the phoretic canvass that occurred more than a year ago and anything that has transpired in between. If the court adjudicates Mr. Hillygus competent to proceed to adjudication, I want both Mr. Hillygus and Mr. Stege, either at that time or shortly thereafter, to be prepared to, I want to set a pre-trial conference when everyone is here and ready to go over what happens next in preparing the case for trial, both against Mr. Hillygus and Mr. Hanty. So we really need to be prepared for any lawful track that is ordered as a result of that hearing. But I don't want this to be drawn out any longer. I don't want this to linger. We need closure, at least at some level, on June 12th by the early afternoon, unless something remarkable happens outside people's control. So you're set for 9 o'clock. I have nothing else scheduled that morning, and I can even go to early afternoon if need be. That's the order of the court. Mr. Stege, anything else from the state at this point?
Thank you, no.
Ms. Reynolds, anything else?
Your Honor, Mr. Hillygus has requested me to request a jury trial to determine the matter of competence.
Okay, the court will take that under advisement and make a decision on that when I see you all on June 12th. Thank you very much, everyone. The court will be in recess.
All rise.